Welcome back to Dolor Factor Live. We're talking about the laws of succession. We're trying our best to encourage you to start thinking about getting your will done or updating your will. Now is the time for you to share your experiences with us or to comment on anything that we've said or not said tonight. So we're waiting for your calls. And whilst we're waiting for your calls, I'm going to go through a couple of the questions that we've been asked tonight. Can any of your guests clarify what is co-ownership and joint ownership? Veronica?
Yeah, well, in St. Lucia, we have what is called co-ownership as opposed to what people are accustomed to in the UK called joint ownership. So when you are a joint owner, if you're deceased and the other co-owner, the other joint owner gets everything. But in St. Lucia, the co-owner's property goes to the estate of that person and not to the other owner.
Right, and I think that needs repeating, but we have a call. Hello, welcome to Dolor Factor Live. Thank you for calling.
Hi, good evening.
Good evening.
I'm just calling to find out if you have somebody who donated a deed of donation, which is an elderly, they're about 98, 99 years old, and who went in a coma at the time she did it, was ill. What would that be?
She was in a coma?
Yes, she was in a coma, and about 2 days after, she was taken by a grandchild to pass the land, donate that land to him.
But if she was in a coma, that means she was not of sound mind.
Well, that was a deed of donation. If she was in a coma, she didn't have the legal capacity to enter into a contract.
Pardon?
If she was in a coma, she did not have the capacity to understand what she was doing and to enter into any sort of contract, including a deed of donation. So if there's medical evidence to show that she was in a coma at the time, then that is something that can be challenged.
Yes, there is medical evidence, because we do have that. That she was in a coma at that time, and it was the same day she was taken to visit the doctor.
No, but who signed it?
It was by a lawyer, done by one lawyer, the grandchild, and the lady.
And the lady signed the deed of donation?
That's what they're saying, but she's not capable of holding a cup.
Exactly. If she was incapable of signing, somebody forged her signature.
That's what we're thinking right now, so I was quite happy that the show was on tonight, that I would call to find out what I could do with regards to the law and anything else. Because I have the paper in front of me saying that she signed, it was herself, the grandchild, and the lawyer.
Well, in a circumstance like that, if somebody, because of her age as well, any prudent lawyer, I have to say, has to ensure that there is a second notary who can attest to what is happening. And there is a recent decision from our courts that said in those circumstances where there is a medical issue, the lawyer ought to have been advised by a medical professional as to the competence of that person when they executed that document. And if they didn't do it, then that document is subject to challenge. It ought to be challenged. You have a very good case.
Okay, because we spoke to the doctor, we got the medical, and no such thing. Nobody went to the doctor with regards to her status. The medical report shows that she was in a coma a couple of days, because when she got back home, she said that she went somewhere. She doesn't know where she went, and people were speaking to her.
Is she still alive?
Yes, she is.
Can I suggest something? Because I know we have lots of people wanting to ask questions. Perhaps at the end of the program, we will actually give out contact numbers for Andrea and also for Veronica. And perhaps if you take the contact numbers and you can further the discussion with both of them. Is that okay with you, Veronica and Andrea? Yes? Caller, is that all right?
That is fine.
Thank you very much, and thank you so much for calling.
You're welcome, thank you.
And that's for anyone else out there. If you are worried about something, please give us a call, because you know other people might be sitting there worrying as well, but perhaps not brave enough to call. And these things are just so important. That was a very serious thing. Back to the phone. Hello, welcome to Dolor Factor Live.
Hi, good evening.
Good evening.
Very interesting topic.
Thank you.
Yes, I have a question concerning will and life insurance. I would like to know, would a will supersede the beneficiary on life insurance?
Simply no.
Pardon me?
No, it will not.
Why is that?
Because the insurance policy is not part of the estate of an individual, and it is considered as a separate type of property in law. So at the end of the day, the policy takes effect, and the beneficiary in the policy is the only person who can get it. But
Good, that's correct. That is correct. Yeah, that's correct.
Thanks very much.
You're welcome.
Thank you. Again, here you go. We sit down and we assume that we know what's right until it's too late. Someone dies, they don't leave a will, and because we assume everything is going to be okay. Now, if this lady hadn't called the program tonight, she might have lived her life assuming everything was okay, then to find out it wasn't. Back to the lines. Hello, welcome to Dolor Factor Live.
Hi, good night. That's question from Cenac. I just want to let you know that.
Oh, I'm sorry we've lost you. Perhaps you can give us a call back. Here's an email that has come through, and I have a feeling we'll be interrupted by a call, but I'll start. If someone died and the caretaker, who is a relative, all right, here's another call. We'll go through that question. I won't forget. Hello, welcome to Dolor Factor Live.
Hi, good evening.
Good evening.
This is to the two attorneys, the lawyers actually. If you have a situation where you have property that's supposed to be your heirs, you become an heir to property along with other members of family, all right, of that family, but you cannot find. Well, let me give you exactly what happened. There are two granduncles of ours who appear on this these papers, this document. We do not know where to find them.
Is it a declaration?
We do not know anything
succession
about them. We do not know if where they died and if they have children, but yet still I'm being told by one of our lawyers that we have to find out something about them so that we can probate the property and so on. So what I want to know is if they have a time limit for you to go back to find out, because it seems like since 1948.
Wow.
One of them for sure never, in fact, both of them never appeared in any document in St. Lucia.
Okay.
And someone signed, one of my uncle actually signed for them on behalf of them in 1948 for some property that was being sold. What can be done about that?
So your granduncle, so they'll be very old at this point in time.
I can hardly hear you there.
Oh, sorry. You said they were your granduncles, right?
They were my granduncles. The two of them were my granduncles.
And what document named them? Is it a will?
No, it's a declaration
of succession
done by a grandaunt of mine.
Yes, okay, that's a declaration of succession.
Succession, right. Since 1948, of many pieces of property.
All right, caller, can I just ask you to let her answer, because again, we have so many calls, so we want to get as tight as possible.
Okay, so that means, and what happened, in that case, the property has already been passed on to everybody. What you need to do, you need their signatures on the document. If you can't get anything, then you might have to put in an application for presumption of death. You know, if after for 7 years you haven't heard anything from the person and whatnot, you can apply to the court and do that, and if you succeed on that, then you can proceed to the next step and partition the property, which is, I suspect, what you're trying to do, sell or partition the property, right?
Okay. Thank you very much.
Yeah. Okay. And again, caller, we will be giving out information from Veronica and Andrea, so you can contact them later. Anyone else would like to call? Feel free to do so. I'll continue with the email call. Hello. Good night. Welcome to Dolor Factor Live.
Hello.
Hello. Hello. Yes, you're on Dolor Factor Live.
The answer for the question is.
Oh, don't give us any answers to the questions. Okay, the producer will take that from you. At the moment, we're actually allowing the viewers to ask us any questions they want on wills, okay? All right? Okay, let's go back to the email. If someone died and the caretaker, who is a relative, who also had a power of attorney, withdrew over $100,000 in the bank before the will was read, what can the family do? Huge one.
Well, I imagine
they withdrew the money after the person died. They were a relative. They had power of attorney. They withdrew over $100,000 in the bank
after
the person died, but before the will was read.
After the person died?
Yes,
By virtue
because
of
they
the
had power of attorney, they took the money
The
out.
power of attorney lapsed on
death.
the second of death.
Yeah.
It's gone.
It's no longer valid.
So the bank, well, if the bank did not know, but did they have to account? They can be called to account for those sums and to repay those sums, because they then had no power to have withdrawn the sums.
So in effect, that's stealing. That's
Exactly.
theft.
Exactly.
Right. Okay. So that is your answer then. All right. Another question. Okay. Let's go back to the phone lines. Hello. This is Dolor Factor Live. Thank you for calling. Good evening.
About the estate, the dying and the estate in an estate. What happens in that case? Could you explain?
Sorry, could you?
And
Could you repeat the question, because we can't hear you? Can you just be a little louder?
About estate planning and wills. You're not hearing?
Oh, estate planning and wills?
Right.
Okay.
I need to understand. I need you to explain the difference. What happens in the case of estate when somebody dies and they leave everything to estate? You getting that?
When you want to find out what if someone dies?
If somebody dies and they left everything to their estate.
They left everything to the estate.
What happens in that time, in that regard? And secondly, how long after the person dies can the heirs start claiming or start distributing property?
Oh, okay. Do you understand that?
I'm not hearing clearly.
Caller, the first question we didn't quite understand. I think I heard you ask, what happens when somebody leaves everything to the estate?
Right.
Okay. The estate. You mean when do you want to know when they leave a will, or if
when
they don't?
Leave everything, there's no will.
Or when there's no will.
There's no will.
Okay.
And they leave everything to the estate. There's a wife,
yes,
and then there's children. One legitimate and one not.
Okay.
And then at what stage does the law permit things to be distributed according to the estate?
All right. In terms of the stage, you can apply for representation. So somebody has to apply for a document called letters of administration.
Who is that somebody?
Right. So if you have a wife and children, the wife has first entitlement, and thereafter the children, the oldest, and going down the line.
Oh, okay.
Right. Are first entitled to letters of administration. So there is an order of priority set out in law. In terms of the illegitimate child, because there is a wife and children, then the illegitimate child cannot inherit. But whoever are the heirs can decide when they pass in the property to give that illegitimate child whatever it is they want.
Okay.
So that's what happens so the wife in that case can get a third of the estate, and the child gets the other 2/3 if there's one child. That is if she renounces her half share in the community property.
But then if the child is not part of although the child is legitimate, but the child is not legitimate in the marriage, that particular marriage, but from a former marriage.
Oh no. If the child is from a former marriage, so the child is legitimate?
The child is a child from a former marriage.
Or that child also shares. So the child gets 2/3 and the wife gets a third.
Okay.
Or the wife can keep all of her community and not participate in the estate at all.
Okay.
That's what happens.
And how soon after can they start distributing? Does the law give a period of time?
Well,
14 days after the deceased has passed, you can apply for the letters of administration.
Okay, 14 days after.
Yeah.
Okay then, thank you.
Okay, thank you very much. Let me just go through a couple. We've got so many questions. I'm going to just give this statement and then we're going to go straight to a break. You spoke about an illegitimate child. What if that child was already born before the father got married? What happens to the child's inheritance? I think that's very similar to what we just said, but I think when we come back from the break, Veronica will answer that. This is Dolor Factor Live on DBS. Please stay with us. We'll be right back.